You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 113. Should I be afraid that my patent attorney will steal my idea? My name is Adam Diamond, a registered patent attorney and founder and owner of Diamond Patent Law in Los Angeles, California. I can be contacted through my website at diamondpatentlaw.com. That's DIAMENT, patentlaw.com, or call me at 424-281-0162. I have potential clients call me all the time and want me to give them advice about their invention, but they're afraid to tell me anything about it. Now, it's understandable because you're always hearing from patent attorneys to not tell people about your invention before filing an application without a non-disclosure agreement, because someone might steal your invention, and also your disclosure to someone else might be used against you to reject your own patent application, because if you tell people about your invention, then your invention is considered public. And if your invention is public, then you can't get a patent on it. So what about disclosing things to your patent attorney without signing a non-disclosure agreement because you don't want the patent attorney stealing your idea? For the most part, patent attorneys are not interested in trying to market your idea. They're too busy doing attorney stuff, and then to try to be in business and marketing for a product that they didn't invent, they're just not interested. Now, I know you think your idea is worth $1 million, but patent attorneys know they know it takes a lot of work to make a product successful, and that's not their attorney skills. Those aren't the skills to make a product successful, while at the same time trying to do a successful product, and they're trying to run a law firm. It just is not going to happen. And actually, here's the sad truth. The vast majority, probably well over 95% of patent applications, never have a product that makes any money. The patent attorney is going to make more money filing and prosecuting your patent application than trying to take your invention and make money off the invention itself. Okay, so you've heard what I've said and you still don't believe me. You think that if you tell an attorney your idea and you didn't sign a non-disclosure agreement, that they're going to steal your idea, and you don't really believe that the attorney is not going to steal it because they actually refuse to sign a non-disclosure agreement, which sounds really fishy. Why wouldn't they just sign the non-disclosure agreement if they have no intention of stealing your invention? And the main reason is that there's already a non-disclosure agreement in existence without any paperwork from you. And this is from something called attorney-client privilege. Attorneys are not allowed to disclose communications from you without your permission. Now, this is similar to the doctor-patient privilege. When you go to your doctor, do you ask her to sign a non-disclosure agreement to not tell anyone about your condition? Probably not. And it's because it's a violation of doctor-patient confidentiality. There's HIPAA violations, and the doctor could lose their license. So there's no need to have a doctor sign an NDA because not disclosing your condition. It's already part of the law. Same thing for attorneys. I'm in California, but it's probably similar in other states, that even if you never hire the attorney, the information you tell them is still confidential if the conversation is related to you possibly retaining the attorney. I'm going to read a short part from the Ninth Circuit Court of Appeals in a case called Barron v. United States District Court for the Central District of California. And it says, prospective clients' communications with a view to obtaining legal services are plainly covered by the attorney-client privilege under California law, regardless of whether they have retained the lawyer and regardless of whether they ever retained the lawyer. So that comes from that one case. If you also look at the State Bar of California rules of professional conduct for California, this is Rule 1.18b. It says, even when no lawyer-client relationship ensues, a lawyer who has communicated with a prospective client shall not use or reveal information. There's a lot of detail after that, but the gist of it is that even if there's no lawyer-client relationship, the lawyer still can't reveal that information. Now, there are some exceptions, like you're threatening to kill someone, an attorney can break that confidentiality, or if you sue your lawyer for malpractice, there are things that you could reveal to a judge to try to clear your name. But for the most part, if you're just talking business, everything that you say is already confidential. So if everything is confidential, why won't the attorney sign the non-disclosure agreement anyway? And it's because we already have our own rules of non-disclosure and when we're allowed to disclose. And your non-disclosure agreement probably isn't going to cover those things in the same way. Do you have in your agreement that I'm allowed to talk to a patent examiner? What about my patent drawings person? What about a judge? What if I need to talk to another attorney to assist me? All these things are necessary to get your patent allowed, but a generic non-disclosure agreement is not going to cover all those things, and will just cause too much of a mess if I have to follow the Ninth Circuit rules, state ethics rules, and patent office rules, and now you have your own rules that you're coming up, and there might be conflicts. So now maybe you're thinking, well, why don't you just have a non-disclosure agreement that says that you'll follow the non-disclosure rules of all those places? And it's because I'm already bound by those rules. And actually, I do have in my retainer agreement a section that says I'm bound by the confidentiality according to California and patent office rules. I actually don't need to put that in because whether it's there or not, I'm already bound by those rules. But clients often like to see something that looks like a non-disclosure agreement. So I put it in there, but it's really redundant. So can a patent attorney steal your invention? I mean, technically they could try, but is it worth them losing their license to practice law, going to jail for the off chance that your invention is actually worth something? Patent attorneys really just want to practice patent law. They're not interested in becoming product entrepreneurs. I cannot find a single instance of a patent attorney ever stealing an invention for their own benefit. They're too busy. They're not interested in it. It's against the law. They could lose their license. They could go to jail. So I think you can be pretty safe talking to a patent attorney about your invention, even without a non-disclosure agreement. If you want help with your patent application, trademarks, copyrights, responding to rejections, appeals, anything else related to your invention, you can contact me directly through my website at diamondpatentlaw.com. That's DIAMENT, patentlaw.com. Email me at adam@diamondpatentlaw.com or call me at 424-281-0162. I'm Adam Diamond, and until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamond. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamond at patentingforinventors.com. That's patentingforinventors.com. Or call Diamond Patent Law at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.